much. Mr. Fonzone, welcome. I hope we will get through the issues I addressed earlier and we can proceed swiftly to your confirmation. I served as United States Attorney back in the Clinton administration, and at the time, the Office of Legal Counsel was viewed essentially as the high temple of legal excellence and integrity. And since I've been in the Senate, things have gone rather awry. We first had the warrantless wiretapping opinions, which were so appalling that when they became public, the colleagues of OLC in the Department of Justice threatened to resign en masse if the program was not restructured, notwithstanding OLC's prior secret opinions approving of it. Then, not long after that, the torture program came along, again supported by OLC opinions, in this case so bad that the department actually turned around and withdrew the opinions. And indeed, they were so bad that the department later offered the opinion that OLC lawyers were not subject to the duty of candor, that an ordinary workaday lawyer going into the J. Joseph Garrahy Judicial Center in Providence, Rhode Island, with 6 files under his arm is subject to on a busy, busy day, that these elite, Ivy-educated, super high-performing lawyers would not be held even to that standard. Now, that did quell the problem of how bad the opinions were, but it set, I think, a very bad example by exempting OLC from the most basic standard for workaday lawyers. And then we moved on to the issue of executive versus legislative access to documents, oversight, and so forth. And as you know, OLC used to, under the Reagan memo, which is still nominally in play, used to have a duty to be kind of an ombudsman or arbiter, to take a fair and neutral position and try to find common ground between the legislative ask and the agency priorities. That changed dramatically to the point where the OLC became the outermost reach of the most arcane and exotic doctrines of executive supremacy, virtually autocratic doctrines. And then when those doctrines appeared in Article III courts and were mocked and rejected, the position of OLC was, well, that wasn't the Supreme Court, so it doesn't count. As you were advising companies, would you overlook a district court decision in the jurisdiction in providing advice about what that company should or shouldn't do?
So, Senator, there's a lot there. I guess I'd
just that last question. I'm not asking you to respond to the whole mess.
Yeah. Obviously, when I was advising companies, I would not advise them to ignore relevant precedent.
Yeah,
and
I mean, it just seems a little weird that OLC treats itself like it's another circuit court of appeals, and its judgments can only be repaired or corrected by the United States Supreme Court. It leaves an enormous gap between what the law is and what OLC is telling people that can persist for years and years and years and years until the Supreme Court addresses it. And it's a matter of real concern for us because we think, I think in Congress, that a lot of the ideas that the OLC has propounded are really, really badly wrong. And Senator Kennedy and I have worked together on finding an alternative method because we've given up on the good faith and neutrality of OLC in this regard. So we're creating, in a bipartisan fashion, with a bipartisan report and a bipartisan bill, an alternative. So given this challenging history for what used to be the high temple of legal excellence, and we can have this discussion more, but I'm interested in what guardrails you think OLC should build for itself to prevent another warrantless wiretapping fiasco, another torture opinions fiasco, and another walk away from department policy as expressed in the Reagan memo and from the rule of law where Article III courts have opined.
Thank you, Senator. And I'm not going to sit here and say OLC's always gotten it right. And as you've said, there's times when they haven't gotten it right. And I think the only thing the office can do to establish trust is to deliver the best advice it can, frank and independent advice, and to do that consistent with its best practices that have been stated publicly, which I think there's three main sort of buckets of them. One is that it gives frank, independent advice that's its best view of the law, independent of the policy preferences of any administration. Secondly, that it only gives that advice after rigorously vetting it and after thorough deliberation between the career attorneys in the office and the appointed leadership. And then third, to the extent it can, it makes its advice public so it could be subject to scrutiny. OLC answers the type of questions not everyone's always going to agree upon, but I think it owes it to the American people to give advice consistent with those best practices.
Thank you, Chairman. To be continued.
Senator Graham.